A federal judge just lost patience in open court in a way that almost never happens, and the reason it happened tells you everything about where the relationship between the Trump administration and the federal judiciary currently stands. This was not a tense exchange or a pointed question from the bench. This was a judge who has been watching the same pattern repeat itself case after case, reaching a breaking point in real time with cameras rolling and a packed courtroom watching. Make sure to subscribe so you never miss a video and watch this.
Ms. Dean.
Thank you, Chairman Rogers. Thank you to our ranking members. Welcome, Acting Attorney General. I want to speak about justice for the Epstein victims and survivors. And I'm going to begin with the closing words of Virginia Roberts Giuffre in her book. It's literally the last paragraph. She writes, "I hope for a world in which predators are punished, not protected. Victims are treated with compassion, not shamed, and powerful people face the same consequences as anyone else. I yearn, too, for a world in which the perpetrators face more shame than their victims do, and where anyone who's been trafficked can confront their abusers when they are ready, no matter how much time has passed. We don't live in this world yet. I mean, seriously, where are those videotapes the FBI confiscated from Epstein's houses? And why haven't they led to prosecution of any more abusers?" That's from Virginia. It was printed, as you know, posthumously after her death. Mr. Blanche, you and I had a chance a couple of weeks ago at the Department of Justice to speak about these cases. We discussed three things in connection with this monstrous, decades-long crime spree. Number one, your failure to fully redact survivor information. Number two, your failure to follow the law and release the remaining files. And number three, your refusal to prosecute anybody else. Mr. Blanche, let's continue that inane conversation, but this time it's public. This time, and more importantly, it's under oath. You're speaking to Congress. So let's get into it. When will you comply with the law and release all of the files?
As I said to you when we spoke before, we have complied with the law. We have reviewed.
There are 3 million more documents, and you know what you said to me? They're all duplicative, and they include another guy named Epstein.
No, I didn't
Nobody's
say that.
buying. That's
I did
what
not
you said.
say that.
That's what you said.
So look,
Reclaiming my
can
time.
I answer? Can I answer the question?
You may not. I
Okay.
just gave you the answer you gave me.
Telling.
No, actually, it's my time, Mr. Chairman. I think those are the rules of this committee. I told him the answer he gave me, and now in public he's trying to say something else. Please stop the clock. Can I get that time back? May I have 20 seconds back, Mr. Chairman? Thank you. I very much appreciate that. Mr. Blanche.
You don't want me to answer the question.
Mr. Blanche, as you know, I visited DOJ 3 times for as much as 10 hours, and I'll be going back. Does the Epstein File Transparency Act say that the files should be available to members of Congress with a minder at DOJ, where you're in a secure room, you can't write on any of the binders, you can take your own notes? Is that what the Transparency Act says?
It doesn't require we allow you to come to DOJ at all. We did that on our own.
What does it say in terms of
we do that.
transparency? It says that they should be made publicly available.
And they
Am
were.
Am I correct?
And they
Publicly
were.
available.
And they were.
Oh, well, let's talk about that.
Okay.
Time of the gentlelady has expired.
I beg your pardon. And I'd actually like to get 20 seconds back. How do I get cut off 2 minutes into this?
2 minutes and 10 seconds left.
Time of the gentlelady has expired.
I beg your pardon, Mr. Chairman.
No, that's not right.
What rules are we operating under? Because he's under a little bit of heat for not prosecuting anyone in these monstrous crimes? I've been in the room. I have been there. This is what I had to do, to transcribe, to show what is true. What is true is that the president has lied about being on Epstein's plane, and the unredacted files prove that. There's a lot in here. I am shocked at this. There's also this set of files in the file. This is investigation into the potential co-conspirators of Jeffrey Epstein. I almost used up all the blank ink in the hallway because it's all covered up. It's all covered up. The American people are not stupid. They know that when members of Congress have to go in and actually unredact to try to find the truth for these victims, something is corrupt, something is corrosive. You were paid $10 million to represent the president. You hang a 30-foot banner of the president's menacing face over the entrance to the Department of Justice. You said that if you were terminated or not moved forward as Attorney General, you would say to the president, "I love you, sir." So I have one question for you. Is your obligation to the victims and survivors of Epstein's heinous crimes and all his perpetrators, or is your first obligation to the President of the United States?
So without a doubt, we want to bring justice to every victim.
When will you bring that justice?
Can I please finish?
Excuse me.
Can I finish?
It's been decades. When will
Can
you
I
bring,
finish?
When will you bring the justice?
So as I was saying,
When will you prosecute?
Oh,
And who will you prosecute?
can I
Please
speak?
allow the witness to answer.
You told
the
me
question.
in our
So I'll tell
conversation you
so
blamed the victims.
Every victim
Let the record
of Mr.
reflect,
Epstein.
he told me
of-
that the
of-
victims didn't give good names.
let me be crystal clear that this Department of Justice will always protect victims and will always prosecute anybody we can, okay? Full stop, no ifs, ands, or buts, okay? What you are showing in a game of showmanship are redactions because of victims, because that prosecution memorandum
Perpetrators.
talks about, excuse me?
Perpetrators, too.
How do you know that? Go ahead.
Talk to the
Exactly.
victims.
So
Talk to the victims.
they're victims' names, which we are required to redact, required by law to redact, which we did. Okay? So I take
Mr.
umbrage
Chairman,
to
I
the
realize
idea.
I'm over time. I thank you for that indulgence. I want to ask for unanimous consent to enter records onto the record. May I do that now?
Without objection.
Thank you. The
Time
first,
of the gentlelady has expired. Thank you, Judge. Mr. Laurel?
Thank you, Mr. Chairman. If I could just follow up on my colleague Congresswoman Meng's questions. I have here, this is the order on the settlement, the $1.8 billion. And then this is the addendum to the order, which is about tax immunity. And this is a copy of the settlement agreement. And the Associate Attorney General signed this. These two documents were signed by yourself. Now, this is all in writing. This is all, can you tell us here today that you are going to disavow this, that you're going to rescind what you said to Ms. Meng in writing with these efforts? These three documents are in writing. Is that a yes or a no?
So I can't answer that yes or no. Do you want an answer?
Yeah.
Okay, so not yes or no. You gave me three documents. The only document I said we're not moving forward on today is the first document identified, which is the anti-weaponization fund. There's still a settlement agreement, and there's still the second document I signed is not an addendum. It's a separate Attorney General order.
Okay. Okay. So, but you're not going to rescind the addendum, not an addendum, the second order?
No,
The only thing you're talking about here, so the blanket immunity is not something that you're going to move back on?
it's not blanket immunity. That's not true.
It is.
No, it's not.
Okay. United States releases, waives, acquits, and forever discharges each of the plaintiffs from and is hereby forever barred and precluded from prosecuting or pursuing any and all claims, counterclaims, causes of actions, appeals, requests for any reliefs. I mean, this is an order from you, but you're not prepared. You are prepared to say that the president and his family will be barred, are immune from. That's a yes.
No, it was not a yes. I had not answered the question. I can't answer if you want me to.
What are you doing with this?
Okay, so there was a settlement, which is one of the documents you
Yes.
showed. Okay.
Right.
Part of the settlement included the second order that you just held up.
Right.
And that is still, nothing has changed with that. What I said today, what I've said a couple times today, as what we talked about yesterday, is we're not moving forward with the anti-weaponization fund.
Okay, but you are moving forward with this second order?
It's not moving forward. There's a settlement that the IRS entered into with President Trump and others, his family and his companies. As part of that settlement, as is customary in IRS settlements,
You're an attorney.
there's a separate AG order.
Friends, listen to what is being said here today here. This is really pretty extraordinary, that we are going to forever barred and precluded from examining or prosecuting the president, his sons, and the Trump organization's current tax filings. Simply put, you just gave the president and his family a tax immunity to the tune of about $100 million.
Not true.
Well, yes, you have, my
No,
friend.
it's not true.
You know, look, and I just want to say this. The Save America paid you nearly $10 million between March of 2024 and December of 2024 to serve as the President Trump's personal defense attorney. My
What did you
God,
say?
don't you not find there's any conflict of interest in what you are doing here as the acting Attorney General of the United States?
I didn't. What are you saying is a conflict? I don't understand what you're saying.
Listen.
The fact that I used to have a job and I have a current job?
You know, I've got less time left, but I take. I'm going to reclaim my time because I think you have clearly answered where you're going on what you're doing on this. Is that you've taken one piece and you said, okay, we have had a ton of backlash on this on this $1.8 billion slush fund. However, so we'll not move on that, but as part of the settlement, which you've said, which is this immunity for the president and his family and his business, et cetera, that stands. Thank you for that.
It's not immunity, ma'am. It's
Thank you.
It's a promise.
Thank you. It's immunity.
It's not immunity. It's not immunity. Okay, so it's not immunity. What it says is like any time the IRS settles with an individual taxpayer or another company as part of the settlement, it's standard. It's typical to get rid of past ongoing audits. It's not a forward-looking document. It's nothing that gives any sort of immunity in the future to the president or his family or his organizations. And so by you saying that, it's not true.
By you saying what you've said, it is not true. So thank you, and I yield back.
The case involves a man named Kilmar Abrego Garcia, who was deported to El Salvador despite a standing court order explicitly prohibiting his removal. Not a contested order, not an order under appeal. A clear, unambiguous federal court order that said this specific person cannot be sent to El Salvador. The administration sent him anyway, and then told the court it could not bring him back because he is now in Salvadoran custody, and the United States does not control what El Salvador does with people inside its own borders. The judge's response to that argument is what produced the moment everyone is talking about. Are you freaking kidding me? Not paraphrased, not softened for the record. That is what came off the bench. What makes this exchange so significant is not just the language. It is what the language reveals about the state of federal court authority in the current moment. Federal judges have been issuing orders to the Trump administration for months. Those orders have been ignored, delayed, worked around, and in some cases openly defied. The administration has developed a consistent posture of treating court orders as opening positions in a negotiation rather than binding legal obligations that must be complied with immediately and completely. The Supreme Court has already weighed in and told the administration that Abrego Garcia must be facilitated for return. The administration went back to the lower court and argued that facilitate means it has to make some effort, but cannot guarantee any particular outcome. Judge sitting in that courtroom found that argument so disconnected from what the Supreme Court actually said that she expressed her reaction in language that rarely makes it into judicial proceedings. Government's lawyer stood before her and argued that the administration has no legal mechanism to compel a foreign sovereign to release a person from custody. The judge pointed out that the United States government has enormous leverage over El Salvador, billions in aid, military cooperation, security assistance, diplomatic relationships that El Salvador depends on to function. She asked pointedly whether any of those levers had been used, whether a single phone call had been made, whether a single dollar of aid had been conditioned on the return of a man that a federal court ordered should not have been removed in the first place. The answers that came back were not satisfying. There had been conversations, there had been diplomatic engagement, there had not been any concrete action that amounted to what the Supreme Court meant when it said facilitate.